and business lawyer. This is Coffee with a Lawyer, streaming live Facebook, LinkedIn, YouTube, Twitter, and Instagram. This is your chance to ask the lawyer your legal questions for free. Please know there is no attorney-client relationship here. There is no confidentiality. This is only meant to provide general information, is not specific legal advice. If you could, please, we encourage you to keep the questions general. If you need to speak about specifics, it's best to schedule a confidential consultation. And we have two guests on right now. And I'd like to allow Joe to ask any questions he may have.
I don't really have any questions today. I did get that letter that, I'm working with a literary company that they fraudulently, in my opinion, they faked a letterhead saying I had a book contract from a major publisher, and led me to believe that I had a contract. Anyway, I sent them kind of a demand letter saying, make this right. Somebody at the company basically said he was going to make it right. And I got a letter back. I deeply regret about your experiences, and we're committed to understanding what transpired. And, we want to maintain the highest level of integrity. I'm just paraphrasing. And they want to investigate. I'd like to assure you that we'll begin an inquiry into the allegations, and I will personally work with our legal team, blah, blah, blah.
So
I kindly request you allow us some time. Well, I gave them a deadline, and the deadline's tomorrow, so we will see what happens.
Right. I do think your next recourse may be filing in North Carolina small claims. I'm familiar with your matter. I know we discussed a little bit about it at length. And I do think when they put your back against the wall, that's where you have to go. Because of the mountain controversy, unless you want to make it a full-blown legal fight, which will be lengthy and costly, you can start to argue that you lost out on this opportunity, expectation interests. This is what you expected to return from this deal. You were expecting profits around 400, 450,000, etc. That's a difficult argument to make. The more acceptable argument, especially if you're going to go through a small claims process, is the out-of-pocket expenses. Does that make sense, Joe?
Yeah, there's the out-of-pocket expenses, and they committed fraud. They forged the contract.
Yes.
They copied somebody's trademark, so
yes,
they are clearly in the wrong here. I contacted that publisher. They said, you have been scammed. Okay. And so they didn't just take money from me. They committed a criminal act. And I'm willing to make sure that everybody in law enforcement, small claims is part of it, but
well, slow down, Joan. I know where you're going with this. Remember, I sent you that the article on a thin line, and this is what people really don't know.
Right,
there is a very thin line between asserting your legal rights and committing unlawful extortion, and people need to know this. You can't threaten going to the law enforcement in exchange for
I'm just
money.
Do it. I'm not going to threaten.
That's all. You just do it. That's all you do. All right. The threat of it could possibly be interpreted as an unlawful action. That's why I'm telling people it's just best not to do it. But if it is within your legal rights to go to those agencies, you just can't make a threat about it in return for money. It could be considered blackmail and extortion according to the state statutes. All right. Each state has a different statute. Some are rather broad. Some can be specific and actually identify this type of situation. So you do want to be mindful of that. There's a thin line, and people need to know that there's a thin line between making a legal demand and committing extortion. And people mistakenly go over that line sometimes. So you want to be mindful of that.
Yeah, I don't want to cross the line.
Yes.
I did send them a letter and I did request that they respond by October 15th, which is tomorrow. My guess is I should let October 15th complete itself.
Yes.
Should I have no more communication with the company at this point? Or should I say time's up? Or
what you may want to do is send them a spoliation notice.
what?
What we call a spoliation notice. SPOLIOTION. I may have spelled that wrong. SPOLIATION. Spoliation notice.
Okay.
It is a notice to them that this is a civil dispute and that all evidence must be preserved. And if it can be proven after this moment in time in which you gave them notice that they destroyed evidence, then when you proceed at trial, the jury can be instructed to make certain presumptions, meaning that it was harmful to their case. They can presume that if they destroyed it after the time of your notice. It's just another procedural step. It could also communicate to the other party. The bigger message is that you are ready and you're prepared and you're informed and you know what to do. So you send them a spoliation notice. It is to prevent the expoliation of evidence. All right. It's a notice to preserve evidence. And I think in your case, a lot of those correspondence, the emails, the draft documents of the contracts, where did they get these contracts? You can even go so far into discovery, any communication they had with this publisher. Discovery is quite broad. And sometimes that brings the other party to the table because of the limitless bounds of discovery. It just has to be a likelihood that it could lead to admissible evidence. It does not even have to be admissible evidence in the discovery process of litigation. So this step right now, after the 15th, you can reply, please consider this, I didn't receive a response. Please consider this a spoliation notice, preserve all evidence, including all documents and correspondence of and concerning the publisher and your correspondence to me and any drafts of documents and contracts supporting the deal that you pitched to me.
Yeah.
You have no choice but now to pursue your rights in the court of law. That's your next response to them. And what you can do now is start drafting your complaint to file. And it's a choice you want to make, Joe, to proceed in general jurisdiction or to seek the small claims jurisdiction. You will be capped at what you can recover depending on what jurisdiction you file in that particular state court. I mean, in this case, you could make it a federal case. You have diversity of citizenship impossible in an amount in controversy that's over 75,000. You have choices to make. Yeah. You have considerations. All right.
Sure.
So balance everything. We can continue. I think if we want to get more specific, again, this may not be the platform, more general information, but I think still wait and see. And we can continue next week. Also, let's touch base next week. All right.
Yeah. When we talked last week, we knew that today would be the 14th. So that,
yes,
it would not have hit that deadline that I gave them.
Also,
you told me to give them 2 weeks, but I gave them
30 days. Yeah, 30 days is generally reasonable to evaluate a dispute, depending on how much documentation and evidence you support your claims with for them to evaluate. But they're another party. They're involved in this. They know the situation. It's been ongoing. They're not an adjuster evaluating the claim. This is an involved party. So 30 days is fair. You've given them more than enough time. I will also.
They basically said they would get back to me they haven't gotten back to me. So let's see if they actually do that by the 16th. I'll give them the 16th, you know, that one day of grace.
The concrete date that always must be on your radar is the statute of limitation, which for these matters is generally 2 years, but you're going to want to check the state statutes on this because the state law controls the statute of limitation for the claim. You have a lot of choice of law and jurisdiction issues to consider here. All right, because you have multiple states involved, people from different states, and a deal that cross state lines. You have state laws, which may give you more benefit. So you may want to research that, which jurisdiction would be more beneficial for you to pursue this type of claim. It's a
there was federal trademark infringement.
Yeah, but I don't know if you have standing to bring that claim because it's not your trademark.
No, but I do believe that HarperCollins wants to protect their trademark, and I do have access to contacting them to their legal department. So I would be happy to testify on their behalf.
Okay.
That there was something, you know, you can't say that you're making Coca-Cola if you're not licensed to make Coca-Cola. It's you know, it's supposed to be the real thing, and writing contracts on somebody, you know, if I was writing contracts on Justin Sterling's letterhead and Justin Sterling had no idea what was going on here,
it would be,
you would want to protect the name.
I believe the claim that you could assert in that situation, the standing that you have is an unfair competition claim under the Lantham Act. Yes, the Lantham Act also covers trademarks, but it's more of a business protection, consumers dealing with when they're any unfair competition claim. False and misleading advertising.
You're asking me to do business with you based on a contract that you faked. Okay, like that's so uncool. Like if it was a legit contract, then I would be happy to go through the process. But the fact that it was not a legit contract, I was completely deceived.
Yes.
All right. Thanks, Justin.
We also have Anthony here if you want to ask a question.
Right now, I don't really have anything going on right. However, I am looking into maybe developing a short, like shooting it for one of my scripts. And I was wondering, when you take it from the page to the screen, what legal considerations do I need to consider? Do I need to have in place when I start shooting my script, if any?
Good question. When I hear this, I think of your contracts with the your videographer, the people who are going to be involved in this production team. Are they going to be considered employees or independent contractors? Now, if you're hiring union members, they may have to be considered employees, and you may have to do W-2s and withhold tax payments. Ideally, you'd want to contract with them as an independent contractor, and you should have independent contractor agreements ready and available for them to sign. It has to be in writing so that you're protected. Having a contract in an independent contractor agreement is just one factor to consider, and that can protect you from liability if something ever happens in this shooting, this film shooting. And sorry for the pun, because I was thinking about the Russ Alec Baldwin incident. All right. So contracts are important, and liability is can extend to you. So it's important to have your documents in order. All right. And also, it's important that you make it work made for hire or have an assignment of the copyright if they're going to be involved in capturing the content. You want to own all intellectual property rights. So it should be addressed in the contract. Does that make sense, Anthony? So you got to have this in writing. You got to have a good independent contractor / work made for hire, and also with assignment of copyright language in there to fully protect you, so that you acquire the rights from the final production. You want to own all the rights. Remember the magic formula: rights equals the power, and the power is the ability to monetize. If these contracts are not in order, you could have what they call a chain, cloud in the chain of title, because you didn't have a formal written independent contractor agreement. And then maybe later one of the people involved in the production team has a vendetta and wants to cause some trouble in the negotiations of a deal. Does that make sense? So yes, it's important to have your documents in order. And you're essentially, you're acting as a producer now, right? You're taking on this project. Are you working with any other company or team?
No, not right now. Just in the very conceptual stages right now. This is going to be one of the projects for next year.
Right.
So kind of they say you should get information before you start doing big things. So next year will probably be a big year for me as far as taking a leap forward.
Mm.
And probably doing the next step. So I'm either going to do a short or I'm going to do some kind of a sizzle for my scripts. So I met a few people that can help me across the board. But I just want to try to get the most important part, which is going to be the legal aspect, what I should be thinking about.
Yes. I will say this: everyone in the entertainment industries, I believe, should proceed as if they're a producer. All right, you have to be a producer of content. The producers are the business people in the industry, and they tend to negotiate the more favorable, beneficial rights because they're more informed. I will say a good resource that I think anyone involved in the entertainment industry should have is the books published by the attorney Mark Litwack, a very good entertainment attorney. And he has published books of all the different general standard type of agreements you may come across in the entertainment industries. And I think those are very good resources. You should have them in your repertoire so that you're ready. Part of being involved in this industry is efficiency and timing. You got to have these documents ready so you can close the deal. And even if it's a standard contract that you can customize and edit, it's always good to have. And I know Mark Litwack has published a whole library and package of relevant documents and contracts. So I think that's a good resource to have.
Yeah, I signed up to his newsletter. I get his newsletter every once in a while.
Yes, he has a really good newsletter.
He sends out a newsletter once in a blue moon, like once a month, maybe once every 3 months or something like that.
Yes, he's just got a very good newsletter where he publishes entertainment-related legal information, a lot of trademark, a lot of copyright. It's important to know those foundational rights in the industry: trademark, copyright, contracts. Some employment law too gets involved as well. Independent contractor versus employee. It's always an issue. You have to be informed on that issue. Your industry, the entertainment industries, cross many different legal areas. It's a bundle of legal rights that are involved. Not only property rights, but also contract rights. A lot of contract rights. It's very contract driven, and it can be cutthroat. So you have to be informed. Let's see. So we're at about 20 minutes. I do like to keep these meetings relatively brief so we can start our day. Any last questions, comments, or feedback, guys?
Yeah, I was looking at the Lantham Act.
Mm-hmm.
And I don't know if there was a direct advertising. It was more like a direct, but it says the 5 elements are: advertisement of the opposing party was false and misleading. Yes. The advertisements deceived or had the capacity to deceive consumers, yes. The deception had a material effect on purchasing decisions, yes. The misrepresented product or services affects interstate commerce, yes, because we're in different states.
Mhm.
And the movant, I'm not sure what that word means, has been or is likely to be injured as a result of the false advertising.
The movant is the person bringing the claim. So you would be the movement, the one pleading the case. So
So it looks like all 5 criteria are met.
it could be a likely cause of action. Again, it may not be the typical scenario, which is covered by the Lantham Act. You may want to look into the intentions behind the legislation and precedent. You want to maybe research some similar cases that have been decided. You have
Okay.
general fraud, you have misrepresentation, you have violations of the Lantham Act, claims in equity, unjust enrichment. But again, you're only out of pocket about $7,000. You really want to push, if you want to make this case valuable, is you want to push for your expectation interest and maybe even the punitives aspect behind it, because that's always a leverage behind a fraud claim. But I think in your case, because they're trying to pin it on an employee, there must be some type of verification, some type of ratification by the employer. Their position is that this employee was rogue. All right, so there was no agency there for this type of conduct. That's what they're going to
Well,
argue.
they still received money. So the
Unjust.
money that I sent them
Yeah.
was to the company. So they benefited from this, whether it was an employee that was rogue or not.
Yes, and you can also plead in equity that they received an unjust enrichment and a benefit from unlawful behavior, and therefore they're holding this money in constructive trust to return to you in equity, in all fairness. So that's an equitable claim you can make.
All right, cool. I know we're getting to the bottom of the hour here, so
Yeah, very good, guys.
thank
Yeah,
you.
let's check back in next Monday and take care, take action. You guys have a good week.